everyone. Nice to see you all again, and welcome back to Civil Procedure. So we are sticking with costs today, right? We got into costs on Tuesday. So cost awards, people will recall, this is that extra money that the judge may order a party to pay to another party after the litigation is over. And cost awards, unlike damages, cost awards are not paid to compensate anyone for anything that happened in the real world, but rather exist to compensate parties for things that happened in a litigation, or to compensate parties for the fact that litigation and its attendant costs, legal fees and so forth, was even necessary in the first place. So last time we got into the four goals. We looked at the overall policy objectives that this cost award system is supposed to pursue, right? I mean, other litigation systems don't have this cost award business. We do, and the cost award has a lot of different jobs to perform. So indemnification of successful parties, and accounting for problematic behavior during litigation, encouraging proportionality, and encouraging parties to make and accept reasonable settlement offers. So, so today we're going to look at a few more issues around cost awards. We're going to look at a few cases that show how these different goals come into conflict with each other. And in particular, we're going to focus on that settlement promotion goal, which the rules pursue in several ways. And we'll look at Rule 49.10, definitely one of the more complex, arcane rules in the procedure book, but we'll try to get our heads around that. But before we do any of that, I thought we should take a look at the participation questions. So, so some of these might have been a little bit tricky for some people. So the point of them was to draw the connection between these, like the overall goals of cost awards and the factors in Rule 57, right? So, so these are those four goals that I talked about. And then Rule 57.01 sub 1 is this list of 14 factors, right? So I should maybe specify at this point that, you know, these goals, these four goals, this is my invention, right? This is all my effort to try to simplify what those 14 factors are all about. And, you know, in an exam, and of course in court, you don't want to cite these, you want to cite these factors in Rule 57. Which I'll call up here. Yeah, so these 14 factors here that we introduced last time. And the first participation questions were, you looked at, were meant to show the connections, try to get you to kind of understand the connections between those four goals and these 14 factors. Okay, so question one, whether any step in the proceeding was taken through negligence, mistake, or excessive caution, which of the goals does that reflect? Well, this is all about accounting for problematic behavior in litigation, because it's you know, it's not necessarily a matter of someone being malicious or someone doing something which is in bad faith or anything like that. Really, this should be problematic. Bad is not the best word to use here, because it's just anything that a party did inadvertently or through excessive caution. So excessive caution, that would be, you know, if what's a good example of excessive caution in litigation? Maybe, you know, you think that there's a chance that your adversary has not disclosed all relevant documents as they're required to do under Rule 30. So you go ahead and bring a motion to try to seek additional cross-examination, right? A Rule 30.06 motion that we talked about in our unit on discovery. That might be considered excessively cautious. And excessive caution has a price, in the sense that it slows things down and it racks up the fees for other parties. So that's this kind of thing which is going to play out in your cost award. Okay, so here the second question. One goal of cost awards is to indemnify successful parties for legal fees paid. Remember, that's the first of these four things, and probably the one which is most often used. It's a very rare case in which a cost award is made and that award is not made in favor of the successful party. That's kind of the original purpose behind this, which has been joined by all these other things. Okay, so we're looking for parts of 57 that touched on this, and I think people got most of the big ones. So the first place to look is right here, right in the root of 57.01 sub 1. The court considered these things in addition to the result of the proceeding, and the reason why the court considered the result of the proceeding is to try to figure out who succeeded and who did not succeed, and indemnify the successful party. You know, you shouldn't think of this in terms of winning and losing, because it's one case in a million where there is an absolute winner and an absolute loser. Success comes in degrees, and we want to use sort of this broader idea of indemnification to reflect the fact that the award again can kind of be on a sliding scale depending on the extent to which one party or any party was successful. So there's that, and then the principle of indemnity, of course, is the big one. That's right here at the beginning. The apportionment of liability. That's important, right? Especially in cases where multiple defendants. If you've got a plaintiff who claims they've been wronged, and the defendants are all liable, but some of them are more liable than others, then the ones that are more liable will pay a greater share of the plaintiff's costs. I think that's the big ones that are generally relevant on that point. Okay, so here we have a multiple choice question. So this chap, Eikenberry, making a cost decision, refers to this subsection, the amount claimed and the amount recovered in the proceeding. So when you see judges talking about this, when you see a judge comparing how much money was spent or how much time people spent, and they compare that to what it was they were arguing over, that's proportionality reasoning. That's all about whether the amount that was spent, and it could be time or money, or in some cases other sort of resources that are expended, is disproportionate to what the parties were fighting over. So that's the one I was looking for there. Encourage proportionality in litigation. Finally, we have Tweedledee and Tweedledum, who are arguing over this ancient vase, and that goes to trial. And the legal fees for the defendant are $10,000. The court determines that a partial indemnity cost award would be appropriate. So here we want to look at our cost scales. This slide is your cheat sheet for knowing what percentage is going to be paid. Remembering that the base for a cost award is the reasonable legal fees incurred by the party that's going to receive the award, right? And partial indemnity is 60%, which is right here. So we left off last time with the hearing clinic case. Now it's a great case, right? Because it illustrates all these many different things that are going on in a cost award. And it illustrates the fact that being nominally successful, being a plaintiff like these guys who sue and are, the judge issues a judgment in their favor and they're awarded money, that doesn't necessarily mean that they're not going to be the ones paying costs when everything else lines up against them as it did here. But I don't case to cloud in your minds the reality that it's very unusual, right? The standard cost award, the garden variety cost award, is going to be that partial indemnity award to the successful party. Okay, so we're going to talk now about settlement, right? The fourth of our goals. The fourth objective that courts pursue in making cost awards is to encourage parties to make and accept reasonable settlement offers. Now, we already know that the civil procedure has embraced this goal at every juncture, right? We see part of the motive to encourage the type of exhaustive pleading we have is to make sure that the parties understand everything they can about each other's position, which sets the stage for settlement. We have, throughout the process of motions, we looked at lots of judges explicitly telling the lawyers, please go away and settle this. I don't want to have to decide. And then when we get to our section on mediation, which is officially endorsed and required by the rules of civil procedure, we'll see that even further. And the goal of settlement is also very important when we talk about costs. Well, the first thing we need to talk about is what happens if an offer to settle a case is made and accepted. Right? So what happens in civil litigation in which, 90% of cases, the parties voluntarily agree to resolve the case, probably on the basis of the defendant paying a certain amount of money to the plaintiff. So the first thing to know is that usually when parties settle their case, they're also going to settle costs. The typical release and agreement for the settlement of a civil lawsuit will say that the issue of costs is also settled. Right? Because the parties want to bury the hatchet. They don't want to litigate anymore. They don't want to be litigating about costs once they've resolved the main thing that they were fighting over. But that's not always the case, right? Sometimes parties will settle the main dispute, but the offer to settle will not provide for the disposition of the costs. So that's when Rule 49.07 sub 5 comes into play, and it says that so subsection A talks about an offer to settle made by a defendant. So when the defendant makes an offer to settle, the plaintiff is entitled to their costs assessed to the date the plaintiff was served with the offer. What this requires is for the party seeking costs to show when they incurred which portion of the costs, right? So you'll have your list of dockets from your lawyer, which will, assuming it's time-based, will say that, I worked 2 hours on June 5th, 5 hours on June 6th, and then 19 hours on, obviously 19 hours per day, then you should probably be complaining. But 9 hours on June 28th. And so you look at the specific days on which the plaintiff's lawyer billed them, right? And you divide that bill into the hours that were docketed before the defendant's offer was made and the hours that were docketed after the defendant's offer was made. And the plaintiff will get their costs only up to the moment when the defendant's offer was made. Remembering here, we're talking about an accepted offer to settle the case. Okay, so as we know, cost awards are not just for plaintiffs; they're also for defendants. Okay, so never mind. We'll come back to that in a second. We're sticking here with cases where the plaintiff is going to get the costs. But 49.07 sub 5b is where the settlement offer was made by the plaintiff. So here the plaintiff will get their costs up to the date when the notice of acceptance was served. That is to say, when the defendant accepted that settlement offer. So it's kind of an interesting rule. And what we see here is the courts or the system's effort to promote not just settlement, but early settlement, right? Because at the point of settlement is that we save everyone the time and aggravation and expense of civil litigation. The quicker the settlement happens, the better. So if you're a plaintiff and you are thinking about the cost consequences of your behavior, you know that you want to serve that offer as quickly as possible, right? Because that's when you can basically as soon as the defendant accepts it, then you earn more costs that way. Okay, so that's what happens. 49.07 is where you have an offer to settle which was accepted, but the parties failed to settle the issue of costs. Okay, so one thing to maybe think about this, I should say also about 49.07 sub 5b. What this means is that if the plaintiff makes an offer and the defendant kind of dithers, right? Like say it's an offer which is open, which is going to be open for a while, or it has no expiry date, and the defendant just kind of sits on it, or they say, "Oh, we need 3 or 4 weeks to think about it," or maybe we want to bring a motion and see if we succeed on that before we decide whether to accept the plaintiff's settlement offer. The plaintiff will get their costs right up to the date when the defendant accepts it. So this is meant to be a spur to the defendant to accept that offer quickly, and again, furthering the goal of ending the litigation as quickly as possible. Okay, so we come now to unaccepted settlement offers, a more common circumstance, right? Because typically when parties settle the main litigation, they also settle costs. In those cases where they don't settle at all, they don't settle the main litigation, often there will have been one or more outstanding settlement offers. Okay, so let's, I've got a slide here that kind of breaks this down, hoping to make it a bit more straightforward. Okay, so 49.10 sub 1. So there's an offer to settle, and it's made by the plaintiff at least 7 days before the commencement of the hearing. So 49.10 is going to be our a way to get extra costs from making a good settlement offer. But in order to qualify for this extra kind of bonus cost regime, you cannot be making a courthouse steps offer, right? You'll hear lawyers talk about an offer on the courthouse steps, which means the parties are walking up the steps, about to go in court, start their big trial, and on the courthouse steps, someone makes a settlement offer, which is accepted or rejected. So to qualify for this, it can't be a courthouse steps offer. It has to be at least 7 days before the commencement of the hearing. It is not withdrawn and does not expire before the commencement of the hearing. So if this is an offer which, because technically, settlement is just a contract, and an offer to settle is the offer of a contract. So as you know from contracts, when you're making an offer, you can put any terms on it you want. You can say, I'm willing to settle this case for $15, but only if you reply within the next 2.5 seconds, right? That's an offer to settle, but it's not the type of offer to settle that the system can reward you for. Sorry, I think someone might still have their microphone on. I'm getting some background noise. Maybe people could turn that off unless they're talking. So it can't be an offer that withdraws quickly, that's withdrawn or expires quickly. It can't, in fact, be withdrawn or expired any time before the commencement of the hearing. And it's not accepted by the defendant. And the plaintiff obtains a judgment as favorable as or more favorable than the terms of the offer to settle. So colloquially, we say that you have to beat your offer. A party beats their offer if they obtain an adjudicated result which is more favorable to them than what they offered. So you have to meet that condition as well. Then, if all those conditions are met, the plaintiff is entitled to partial indemnity costs to the date the offer to settle was served. So the first part of this, right, the partial indemnity cost to the date the offer to settle was served, that's just the old garden variety entitlement, right? Whenever a plaintiff goes to trial and obtains a judgment in their favor, they can generally expect to receive partial indemnity costs. So here you get that, but this is the bonus, substantial indemnity costs from that date forward. substantial indemnity, you recall, is 1.5 times whatever partial indemnity would be. So again here, if you're invoking Rule 49.10, you have to show the court not only how much did you pay, but when were those dockets, when the lawyer's dockets incurred. Because those dockets that were incurred after the date when your offer to settle was served, you get this bonus extra cost. You get a bigger proportion of those legal fees back the other side. Okay. So this may help explain it, or it may confuse it, depending on whether you're a kind of a graphics learning person or not. But you split your costs into these two categories, right? If you're getting a partial indemnity cost award, then that means you're eating 40 to 50% of it, right? So it's not great. This is a lot better because you get reimbursed for 70 to 90% of what you paid your lawyer during that period after you made the qualifying offer. So that's for the plaintiffs. 49.10 sub 2 is the defendant's version. So where an offer to settle is made by the defendant at least 7 days before the commencement of the hearing, is not withdrawn and does not expire before the commencement of the hearing, so that's the same, and is not accepted by the plaintiff, and the plaintiff obtains a judgment as favorable as or less favorable than the terms of the offer to settle. So that's worth commenting on, right? Because the plaintiff does not have to lose completely for the defendant to invoke Rule 49.10 sub 2. If the defendant makes a qualifying offer and the plaintiff just gets a smaller amount than what the defendant was offering them, then the defendant is qualifying for this kind of the bonus 49.10 costs. So if all that happens, the plaintiff is entitled to partial indemnity costs to the date the offer was served, and the defendant is entitled to partial indemnity costs from that date, unless the court orders otherwise. So it's interesting to compare these two halves of 49.10, right? So in the plaintiff's half, the plaintiff moves from partial indemnity costs up to the offer to substantial indemnity costs after the date of the offer. On the defendant's side, the defendant does not get costs prior to the offer. So why not? I mean, is this unfair to defendants? I mean, it seems like the plaintiffs do better out of this, right? Because the plaintiff go from partial indemnity to substantial indemnity. The defendant goes from not getting costs at all to partial indemnity. And there's no way under 49.10 sub 2 that the defendant can be entitled to substantial indemnity costs. So what's up with that? Is this rigged in favor of plaintiffs? The rule is designed to ensure that they won't be bad faith offers, right? Because you can't buy yourself the benefit of Rule 49.10 by making a bad faith weak offer, right? Because it has to be an offer that you can beat at trial. It has to be an offer which doesn't expire, and an offer which is open, which is made early enough. So what's going on here? I think the reason why we have this asymmetry is that all of this assumes that there is a case, right? That the plaintiff has a legitimate claim for which they're going to be awarded something. Because if they're not awarded, if the claim is completely unmeritorious, then the plaintiff won't be getting any cost anyway, right? Barring bad behavior or something. So on the defendant side, up until the moment when the defendant made the offer, it's still fair to indemnify the plaintiff for that. What it comes down to is that the system is trying to encourage settlement, and if it wants to encourage settlement, it wants to encourage offers which are generous and early, right? Because a generous offer, an offer which makes a real concession to the other side, which really sort of, climbs down and compromises a bit from your sort of initial hard line, that generous offer is the type of offer which is most likely to actually produce a settlement. And the system wants early offers, because the earlier the offer happens, the more expense and agony it spares everyone. So Rule 4.10, both sides of Rule 49.10 are designed to encourage those offers the system wants, right? It has to be early. It has to be always at least 7 days before. And it's also, it incentivizes early offers because it, the sooner you make your offer, the sooner the benefit of Rule 49.10 kicks in. So doesn't the worry that you will have to beat the offer of the court mean you won't offer anything too high? Let's think about a plaintiff's offer in this case. She pays for $12 million. Let's say she offers. She's trying to decide what settlement offer to make. And if she offers to settle for $5 million, which is to say she'll drop the case in exchange for $5 million, she refuses that offer, it goes to trial, she wins $7 million, then she has now beat her offer, right? So the lower her offer is, the more likely it is that she'll be able to beat it. Right? The system wants to incentivize her to make a low settlement offer because it wants a generous concession, a generous compromise on her part, which is more likely to lead to a settlement. So the lower the offer she makes, the more likely it is she thinks she can beat it. And by beating it, she brings herself to the benefit of this. Conversely, for the defendant, right, the system wants the defendant to offer a high number, because that's a generous concession on their part. Will say to themselves, well, look, if we offer to settle for $10 million, then we stand a much better chance of beating that, of getting a lower adjudicated result than if we were to offer only $3 million. So on both sides of the ball, it's supposed to encourage parties to make generous offers and to make them early. And it's, I mean, that's the advice that good lawyers give to their clients, right? Is to think about settlement early, and try to make your settlement offer as generous and early as possible. Okay. Can there be multiple settlement offers? Yes, there can be multiple settlement offers. And Rule 49.10 would be applied to the offer which is most favorable to you, right? So if you have made a series of offers, then the system, then you would sort of move for Rule 49.10 treatment of the compliant offer which is most helpful to you, which is to say the offer which gives you the most costs. It's complicated. There's tricky differences between them, but it may help if you sort of bear in mind the goals, the type of settlement offers that the system is trying to incentivize, and note that all of this is logically designed to elicit those type of settlement offers. Okay, so Persampieri versus Hobbs. This case is here to show how a tension between different goals of cost awards is resolved, right? Specifically, the goal of encouraging proportionality and the goal of encouraging settlement, which push in different directions. So our David in this case is Persampieri, this lady who was not well treated by her insurer. Okay, so Maria Persampieri is an 84-year-old lady who was involved in a car crash, not a catastrophic one, but a significant car crash. And Aviva, her insurer, was, of course, the defendant. So Persampieri, or sorry, disregard Hobbs. Hobbs is just the random dude who's in the other car. Aviva is the real defendant. So Aviva takes a hard line, right? They say early on that they're going to take the position that the plaintiff's injuries would not meet the statutory threshold test under section 267.5 sub 5 of the Insurance Act. Can anyone tell us what this is? The reading does not explain it. Anyone taken auto insurance law or come across this in a past job or something? So what it is, we have like kind of a mixed system for compensating people for motor vehicle injuries in Ontario. We have a statutory accident benefits scheme, which pays relatively modest amounts of money to people without litigation being required, right? So that's SABs, and that's kind of low-level benefits you get for rehabilitation and physical therapy and so on after a car crash. You can't sue the defendant insurance company unless you meet the statutory threshold test, which requires you to prove that you have a permanent serious disfigurement or a permanent serious impairment. Okay, so you don't need to know this except for the context of this case, because you have to pass this threshold if you want to be able to sue at all. You can't pass this threshold, then you're stuck with these pretty meager statutory accident benefit scheme benefits. Okay, so this is hardball, right? Because basically the defendant's saying she's not even seriously injured enough to have the right to bring this suit at all, which means she should get absolutely nothing from us. So paragraph 15, given the legal positions the defendants were taking, the parties all understood that to possibly succeed at trial, plaintiff's counsel would need to call sufficient medical and other evidence to convince a jury that her injuries had been caused by the accident, that they were real, and to prove the quantum of the damages, right? So by taking this position that you're not even badly enough injured to have the right to sue at all, everyone knows that that means the plaintiff is going to have to lead a lot of evidence. It's going to be a jury trial, right? That the defendant has moved for a jury notice and the jury has not been struck out. And we know that jury trials are automatically more expensive and time consuming. And the stakes are high, right? The plaintiff has to lead a lot of evidence just to show that they're entitled to sue at all. So that means we can expect 6 figures in terms of the plaintiff's actual legal bill, in terms of what she's going to have, what her lawyer's time will add up to, and also the disbursements, right? She's going to need a lot of expert evidence, medical testimony, and so forth. So, in other words, this action is disproportionate, right? They are talking about the plaintiff has offered to settle for what was it, $30,000, right? So $10,000 actually at one point, right? At one point she was down to $10,000. The plaintiff served a Rule 49 offer to accept damages of $10,000 for her damages, and yet she wants to spend over $100,000. She ended up spending $200,000 on costs, right? So this is interesting, right? We've heard again and again the system wants to encourage proportionality. We don't want people to spend more money fighting than the value of what they're fighting about. So and the defendant says this, right? They say this is disproportionate. She shouldn't get these costs. We want to give effect to this rule. So why doesn't the defendant win here? How can the court let the plaintiff give the plaintiff a cost award for over $200,000 given the small value of what they were fighting
on? So the court had said that, well, first of all, they looked at like the scale of the cost and then a ruling on reasonableness and proportionality of the costs. And it found that because the plaintiffs had previously offered the 10,000 and they had rejected it, and they had this like 0% tolerance for negotiating, that once the decision was rendered, they were allowed costs which would be at that lower grade, the 50% range, partial indemnity, and then later at the substantial level. And it was kind of like an access to justice thing as well, because they didn't want to deprive the plaintiff of greater protection because of this insurance company like acting improperly.
Right. Okay. That's great. And when you say zero tolerance policy for negotiating, can you explain that a bit more? Who was it who had that attitude?
I'm trying to find it in the readings here. I was going through it again earlier today. You had made the insurer was the one that had the policy, and that was where they were trying to like bully them to say that they weren't going to meet this threshold.
Yes, that's exactly right. Right, the defendant is not playing ball. Right, I mean, you expect in these personal injury cases, the insurer is supposed to come to the table, and we're looking for a resolution. Here, the defendant is taking an absolute hard line on not being willing to do that at all. So what we have in this case is a conflict between two goals of course. On the one hand, we want to encourage proportionality. We don't want people spending vast amounts of money relative to what they're fighting over. But on the other hand, we want to encourage settlement. And when a party is refusing to even engage in settlement negotiations, and that refusal compels their adversary to spend a lot of money, then we're not going to hold that disproportionality against the party that was compelled to spend that money by the other side's intransigence. So paragraph 50 is an important way, right? For this court to let proportionality be the overriding or even the predominant factor would be grossly unfair to the plaintiff, and would be to reward the uncompromising and, in the light of the jury verdict, unreasonable behavior on the part of the insurer. So the jury awarded the plaintiff $67,000. Right? She had offered to settle for $10,000. So she gets the benefit of Rule 49.10, as it now is, right? Because she made that early offer. So this is an example of beating your offer. Offer to sell for $10,000, go to trial, win $67,000. And she made it early enough, and it otherwise complied. And the fact that it took $268,000 in disbursements and legal fees to win that is not going to be held against the plaintiff, because the reason that amount was required was the defendant's intransigence. So does that make sense? It's whenever the law is trying to do a bunch of things simultaneously, like with one little cost order, we're trying to do all these four different things. You're going to have cases where those things collide and it's impossible to advance them all simultaneously. And this just shows that this is an example of a court choosing to de-emphasize proportionality when emphasizing it would do an injustice and also reward and incentivize the type of behavior the defendant engaged in here. Okay, so let's talk a bit more about 49.10. So this always requires a comparison, right? Rule 49.10 always requires a comparison of the offer that was made against what happened at trial. Right, so we're always looking at whether the plaintiff or the defendant obtained a judgment as favorable as or more favorable than the terms of the offer to settle, right? So was it at least as good? Did you at least match it, or ideally beat it? And usually it's money. So that's easy, right? Persampieri versus Hobbs. She offered to settle for $10,000. She got $65,000 at trial. Clearly, she beat her offer. The next case, Hodgson, is about what happens when it's not easy, right? What happens when we're not just talking money, and how can we make that comparison, which is essential to determining whether 49.10 applies or not. Okay, so this is a defamation case, and the defendant was the owner of the Globe and Mail newspaper at the time, and they had a trial. You didn't have the facts, but basically the plaintiff Hodgson was an official, a civil servant with York Region, north of Toronto, and the Globe and Mail wrote that Hodgson was basically corrupt. They said he caused this fraudulent payment to be made from the municipality to a developer who was a buddy of his. Hodgson was fired for this, and he sued for defamation. So in the main action, he was successful, right? It goes all the way up to the Supreme Court of Canada, but ultimately Hodgson wins the lawsuit on the grounds that this newspaper article was false and defamatory, and also malicious, and he was ordered $780,000 in damages. So this case is all about the 49.10 comparison, right? So here's the issue in this case. The plaintiff made a settlement offer, right? That's why we're talking about 49.10. And the plaintiff said, look, defendant, I'll drop this lawsuit if you give me $375,000 plus costs to be assessed, right? So this was one of those offers, settlement offers, that does not settle the costs. So the parties would have had to go to an assessment officer, if not a court, to have those costs assessed. Had this offer been accepted, it was not accepted. Anyway, the settlement offer, $375,000 plus costs to be assessed, and an apology to be printed in the newspaper, the text of which was to be agreed. So apologies are important in civil litigation, right? An apology will often be part of a settlement. It'll often be something that's raised in a mediation. In a family law matter, sometimes it'll be an apology, which kind of creates the basis for an amicable resolution of divorce-related issues. But apology has a special significance in a defamation trial, right? Why are apologies so important in defamation trials? Like, it's not just about the feelings of the plaintiff, right? The plaintiff is going to feel better if they get an apology, but it's about something more than that. Okay, to help get a better reputation, right? We all want to have a better reputation, but in a defamation trial, it's especially important in terms of why you're out of pocket. Like a defamation trial, you remember, it's not just, it's for a damage to your reputation, which can be monetized, right? Like your foregone earnings, or the lost value of your business that came as a result of this defamatory comment or writing. So how is it that an apology can actually, makes the plaintiff whole in a way that money alone can't? And how does it make them whole? It's not just because they feel better. Right, here we go. Yeah, people have got it now, right? If he can now, when he applies for a job in the future, if a future employer says, hey, aren't you that crook that the Globe and Mail outed for, feathering your developer buddy's nest? You can say, no, look, here's the apology they printed where they say it was all a lie, right? So, apologizing for adultery in a family law case is great, and it, makes people feel better and lets them move on with their lives. Here, it does all that, but it also literally undoes, or goes a long way to undoing the monetary loss he would otherwise suffer as a result of foregone future earnings. Okay, so that was the offer, and this is the judgment, right? The judgment is just a $780,000 award of damages to the plaintiff. So the court does not order an apology. Why don't courts order apologies? Why don't they order people to apologize for things? Charter Section 2B, right? It would violate freedom of expression for a court or any other branch of the state to order someone to say something or to apologize at least. Okay, so the 49.10 issue, we've got these two things. We have to do this comparison, right? 49.10 requires us to say whether the plaintiff obtained a judgment as favorable as or more favorable than the terms of the offer to settle. Not easy, because it's not just an apples to apples comparison. It's apples and oranges. What is this? How much is this apology worth? So the court deals with this first by looking at the question of onus, right? And Rule 49.10 sub 3 tells us something about who has to prove this, right? So if the burden of proving that the judgment is as favorable as the terms of the offer to settle, or more or less favorable, as the case may be, is on the party who claims the benefit of sub-rule 1 or 2. The party who claims the benefit of sub-rule. Okay, so just think through this. 49.10 is this one here, right? And this is where a defendant has made an offer to settle, and it was not accepted by the plaintiff. So who is going to, at the cost stage, profit? In whose interest is it going to be to invoke Rule 49.10 sub 2? Because this is an offer that says that the defendant is entitled to partial indemnity costs when they otherwise would not be getting anything, right? Okay, so we're looking for the defendant, right? Maybe these rules aren't clear enough yet. Should I maybe go over 49.10 again? Because these are the whole cost regime. Okay, so so the cost regime is a special extra payment that a court can make to a party to compensate that party for what happened in the litigation. Settlement, promoting the parties, encouraging parties to make and accept reasonable settlement offers, is one of the 4 goals that courts try to pursue when they're making settlement or when they're making cost orders. Rule 49.10 is a rule that promotes it's part of the settlement promotion effort in cost orders, and it does that by encouraging, by giving you bonus costs, giving you extra costs beyond what you would otherwise get if you make a qualifying offer, and that is to say an offer which is generous enough and early enough. And it works, and it has a version for both sides, right? 49.10, maybe I'm confusing people because but this is the same as this, right? So this 49.10, this slide is the same as this rule here. So 49.10 sub 1 is the plaintiff's version, right? They offer, they make the offer early enough, the offer is generous enough, the offer is not accepted. Then if that happens, they can get substantial indemnity costs, whereas otherwise they'd probably just get partial indemnity. But it would be incomplete if we just wanted to encourage the plaintiff, right? It takes 2 to tango. It takes multiple parties to agree to a settlement. Therefore, we also have a version for defendants. And the defendant's version is 49.10 sub 2. Again, the offer's got to be early enough. It's got to be generous enough. And if it is early enough and generous enough, and you beat it, then the defendant gets the benefit of this, which means that the defendant gets costs, partial indemnity costs, after the day when they made that offer. So here I was asking about 49.10 sub 2, and it would be the defendant claiming the benefit of that. But we just got down this because we're talking about this, right? The burden of proof piece, 49.10 sub 3, that it's the defendant which has the burden of making this comparative argument if they are claiming the benefit of 49.2. The plaintiff has to do so if the plaintiff is claiming the benefit of Rule 49.10 sub 1. Okay, so in the Hodgson case, they say this, right? The burden is on the plaintiff here, right? Because the plaintiff is trying to say, look, I beat my offer. It's agreed that the offer was made early enough, right? So that's fine. But the plaintiff will not get the benefit of Rule 49.10 unless they can prove that they beat their offer. So is this better? Is it as favorable as or more favorable than this? Okay, and the defendants say, look, he hasn't discharged his burden. I mean, how can he? This is an apple and oranges comparison. The plaintiff has not proven this. Because the defendants, of course, do not want Rule 49.10 to apply, because if 49.10 does apply, that means they have to, okay, what is it? What will the defendants have to pay? Like, why do the defendants care about this? What extra money will they have to pay if they lose in Hodgson? Substantial indemnity on costs after the offer. That's right. That the defendant is now going to be pushed into paying extra costs, a higher proportion of Hodgson's costs from the date of the offer if they lose this case. Okay, so they say that the unspecified nature of this makes it impossible to compare. Right? It was not really, the defendants say, an offer within the meaning of Rule 49.10. Because they say, look, they didn't even say what the apology was going to be. It's just an apology to be printed. I mean, it's so vague. How can we possibly do this comparison? And if we can't do the comparison, given that the burden is on the plaintiff has not discharged their burden. So they bring up this case, the Hunger Project versus the Council on Mind Abuse, which is the most awesome case name ever. But in that case, they say, look, the case, the offer was in writing, right? So that case also involved an apology and a 49.10 comparison. But in the Hunger Project case, at least the text of the offer was in writing, whereas here, it's not. In this case, there was never any apology and retraction wording associated with it. Okay, so what does the judge say? Well, it all comes back to the policy of encouraging settlement, right? And paragraph 8 is pretty important here. Since offers to settle containing an element of apology ought to be encouraged as a useful means of encouraging resolution, especially in defamation cases, because an apology can effectively undo much of the damage. And therefore, we have to recognize the importance of interpreting the rule to promote its purpose, which is the encouragement of an early settlement. So if we just, got to this comparison point, we sort of throw our hands up and say, oh, it's apples and oranges, we can never decide how much this vague apology is worth, then we would be undermining the purpose of having Rule 49.10 in the first place. Conversely, trying to do the comparison, find a way to make it work, is consonant with that settlement promotion goal. Paragraph 10, the apology of the law. The policy of the law is to encourage apologies. It would undercut this policy to rule that offers containing a demand for an apology are ipso facto outside of Rule 49. And then they get into an interesting kind of point about the vagueness of the offer, right? So the defendant, you recall, says, look, Hodgson didn't even come up with like a specific text that he wanted. Hodgson just said, his offer just said, an apology to be printed. So the defendant says that indeterminacy and vagueness of the offer renders it incapable of comparison with the judgment, therefore Hodgson should lose. What does the judge say about the vagueness or indeterminacy of the plaintiff's offer? Is that a mark against the plaintiff from the judge's point of view?
I think that somewhere in the case it said that when they requested an apology, it's very unlikely that the first offer even if they did provide a text, that the first text would be agreed upon automatically. So the fact that the apology was included it was designed, or it should have been a signal that the other party would be willing to negotiate on the terms of that apology, and just if they were open to it at all, then there would have been a back and forth, which would have encouraged the settlement. Sorry, I'm not saying that eloquently.
Yeah, that's right. It's the indeterminate vague offer opens the door to negotiations, right? Is in fact more likely to lead to a settlement than a specific text would. Therefore, if our policy is to encourage settlements, then we don't want to discourage open-ended, indeterminate discussions of apologies. Okay, so Hodgson's kind of offer. This is the kind of offer which is a good thing, and one which we should be encouraging. Okay, so paragraph 14, Rule 49 can tolerate this element of uncertainty, and in this particular case, it's actually not difficult to decide that the plaintiff was encouraging settlement, right? The plaintiff should be rewarded for what they've done to try to get the parties towards settlement, right? Because the defendant, this is paragraph 16, the defendant just rejected the offer out of hand, right? Didn't show any interest in discussing the apology. And the defendant's settlement offer was $25,000, right? Which is minuscule. So, what it comes down to, I think, is that the plaintiff is playing ball, right? The plaintiff is engaging in a good faith effort to encourage settlement. Therefore, they should get the reward of their Rule 49.10 costs. They don't do an explicit comparison, right? Of is an apology worth more or less than $405,000? But they're able to conclude pretty easily that they did in fact beat the offer. So he's going to get substantial indemnity costs. Is he going to get substantial indemnity costs for the entirety of his legal bill? Okay, so that's a gimme, right? If we like settlement, then we like settlement earlier because it saves us more time. Therefore, 4910 gives that plaintiff the benefit of substantial indemnity costs only from the date when their offer was served, right? To get them to serve that offer earlier and lead to settlement earlier, and that's all that Hodges is going to get as well. Okay. So we have 4910. I will emphasize that this goal of encouraging, making, and accepting reasonable settlement offers is manifested in Rule 49.10, but not only in Rule 4910, right? If you look at the Rule 57 factors, there are other ones that or at least there's one that talks about settlement, right? Which one is that? All right, here we go. Yeah, it's right at the beginning. Any offer to settle or to contribute made in writing. So an offer to contribute would be between when there's multiple defendants, right? So if one of the defendants says, I'll contribute X percent, or I'll contribute $20,000 to a settlement payment to the plaintiff, that would be an offer to contribute. And so Rule 57.01 sub 1 lets the judge consider any offer to settle, including an offer to settle as long as it was made in writing, right? Including one which does not otherwise comply with Rule 49.10. So that courthouse steps offer doesn't help you with 49.10, but that doesn't mean it's irrelevant. That means that you might not get as generous a treatment as you would under here, but it's going in the hopper. And it might, for example, if you made a fairly generous offer, but one that you didn't quite beat, or that you was just a little bit too late or expired and therefore doesn't qualify for this, that still might get you up from 50% to 60 or 65% on your partial indemnity scale. I think that brings us to the end of what we want to say about settlement. Okay, so let's talk about this Cavalieri case, another case with a weird, hard to remember set of numbers, but you can say it as Cavalieri. And what do we want to say about this? It's a case, another case, kind of like Persampieri, which shows us how these different goals, all these different things we're trying to do with the cost award, are reconciled, or what happens when they kind of collide with each other. So the details of the underlying dispute don't really matter. It was an ordinary commercial dispute, which means it was parties basically arguing over money. It's not public interest litigation or charter litigation. So Rosenstein was the lawyer who acted for Cavalieri, and he acted pro bono, which is to say he did not charge any legal fees to his client. And the issue in this case, when it came to cost, and he basically won on behalf of his client. And the issue is this, paragraph 4 sub 1, is pro bono counsel entitled to ask for costs, or does volunteering to act pro bono mean that the services are offered for free and no remuneration or reimbursement is allowed? So specifically, we're asking this question here about private commercial actions, right? It was settled law before this case that if you were bringing kind of a public interest or charter case and you were working pro bono, you would be entitled to your costs from the other side. But what about if you're just helping out someone who has an ordinary commercial dispute? That was unsettled law before we got to this case. And the court ultimately finds that yes, you can seek costs even though your representation is pro bono. So let's think about this from kind of both sides of it. Who can give us an argument against this? Why is it? Can anyone enunciate an argument why we should not be giving cost awards to parties that were represented pro bono? There's nothing to indemnify. If you had a pro bono lawyer, you paid nothing, you paid no legal fees, so there's nothing to indemnify you for. And so that's an argument against having cost awards go to pro bono lawyers. There's also an argument about the sort of ethos of pro bono, paragraph 7, that where lawyers agree to act pro bono, they have no expectation of payment. They're making a contribution to the administration of justice as part of their professional obligation as lawyers. Right? So this is a noble, wonderful thing you've done. You're acting pro bono, the highest traditions of the legal profession. Why would we want to sully that with a cost award from the other side? Surely that would be inconsistent with the glory of your calling. Okay, so that's there. There's also a point about a windfall. What does that mean? You know what this is all about? So this is an argument raised against. So people should understand what we're talking about here. This is a party represented pro bono. They're lawyers working for free. They succeed. should they then be allowed to seek a cost award from the other side? Right? We already know that under indemnification, it wouldn't make any sense at all. We've got other goals to pursue, but this is another argument against that cost award for the pro bono party. It would be a windfall for the unsuccessful party to avoid paying costs just because the opposite party. Okay, sorry, that's actually on the other side, isn't it? This was the one I was looking for. Yeah, so what's this windfall argument all about? Well, there's two things going on when they talk about windfall. First, they're saying, look, a cost award goes to the party. So if you have a lawyer pro bono and then you win and then the other side has to pay you costs, it's like you're getting money for nothing, right? Because you didn't have to pay your lawyer in the first place. Why should you get that extra money? Then, as we'll see, there's also a windfall argument on the other side. There's also something here which is kind of a complicated argument, but it's about this balance of fear, as they put it. So paragraph 9, the impecunious party has an effective immunity from paying costs. So the impecunious party, impecunious means you're broke, right? And the presumption is that if you have a pro bono lawyer, you are impecunious, you don't have money. So what is it? Why did they say the impecunious party has an effective immunity from paying costs? I mean, that wasn't in Rule 57, right? It doesn't say that, you know, if you're poor, you don't have to pay costs. That wasn't in Courts of Justice Action, Section 131. It's kind of a subtle point, and completely incoherent from some points of view. But the idea is that parties who have no money will effectively not end up paying costs, even if costs are ordered against them. They don't have any money. You can't get blood from a stone, and you know, many cost awards actually don't end up getting paid if they're levied against an individual, because it's hard. They don't have any money, is what it comes down to, right? So they're not going to satisfy that debt, even though the cost award could still be made. Okay, so that's the first point, right? That the impecunious party, the party represented pro bono, effectively doesn't have to fear the costs award system, because the cost award system, among other things, is meant to account for and deter problematic behavior in litigation. It's supposed to be a reason why you say, well, you know, I could make a real jackass of myself in that examination for discovery. I could, like, you know, use every tactical trick in the book. I could refuse to comply with court orders. I could refuse to disclose my documents and produce them the way I'm supposed to under the discovery obligations. I can be a total jerk, but I'm afraid that if I do, there will be cost consequences, right? So it's kind of like there's a disciplinary piece here in cost awards. So normally that disciplinary piece, that incentive to good behavior in litigation, applies equally to both sides, right? Because both sides have an equal incentive to play nicely so that they will be treated well at the cost award station. But now you've got an impecunious party. They're not afraid of that anymore, because the idea here is they won't end up paying any costs de facto, right? They just won't satisfy the cost award if one's made against them. Therefore, they'll feel like they can go nuts. They can be jerks in litigation. They don't have to play along. At least they don't have the same incentive and discipline from the cost award system to play along that their adversary does. Therefore, we shouldn't, if we're not going to have that, we're not going to have the cost discipline on one side, we shouldn't have it on the other side either, right? If the impecunious party doesn't fear the cost system, but their adversary does fear the cost system, then they're going to be at a tactical disadvantage, because the impecunious party can play all the games they want in litigation, their adversary can't. Therefore, the argument is we should not be awarding pro bono costs we should not be ordering costs to pro bono parties because we should not subject the other party to that discipline, that behavioral discipline either, so as to keep a level playing field. I don't know if that makes sense to people. And you won't be examined on it. I thought it's an interesting kind of subtle argument. It doesn't end up carrying the day here because the court goes the other way, right? The court ends up saying, following the arguments in favor of giving cost awards to pro bono parties. So to answer Sarah's question, the defendant, the non-broke party, if they succeed, they will be entitled to a cost award to indemnify them for their legal expenses. But if the party that sued the pecunious party has no money, if they're effectively bankrupt, then de facto they won't end up paying it. And so that's the reasoning. Okay, so the court goes the other way. The court accepts the arguments in favor of cost awards for pro bono parties. They say that indemnification is not the only purpose, right? So just because there's nothing to indemnify the party for doesn't mean we shouldn't be using the cost system to accomplish all these other goals, which are just as alive in a pro bono case as they are in any other. They reject, in principle, the argument that it's inconsistent with the principle of pro bono. I mean, pro bono means you're helping out someone who needs the help, who won't be able to access justice without you doing that for them. There's no inconsistency between doing that and saying to the other side, right, the side that wronged your client and put you in the position of having to work for free in the first place to help your client. There's nothing inconsistent with saying to that party, look, you put us through the ringer on this, man, pony up the way you normally would. And in fact, it would be a windfall to that defendant, right? If the defendant would normally have to indemnify the plaintiff, why should the defendant be off the hook just because the plaintiff was fortunate enough to have a lawyer work for free? So the judge is going to allow these courts, is going to say that that cost awards can apply to pro bono parties. And the only real remaining problem with this is the idea of a windfall to the plaintiff, right? That cost awards belong to the party, right? So cost awards are assessed not on a lawyer typically, but rather on the party, and they're payable to the party on the other side. However, and this is an important thing to remember, if you find yourself doing pro bono work, put it in the retainer with your client that if any costs are recovered, you should get them, right? Because that's only fair, given that you might not get anything and you're putting your time on the line. So the court says this is an easy way to deal with that. To deal with that risk is pro bono lawyers can put this in their retainer that they will get personally any cost award that might be coming in. Okay, so there's no prohibition on the award of costs in favor of a pro bono party, and you can consider all that stuff about behavioral law go into the hopper, but the award is possible in principle. So that's I think enough about that. The last issue with regard to cost that we tackle is the liability for lawyers to pay costs personally. So if we go back to Section 131 of the Courts of Justice Act, you remember this is kind of like the granddaddy of costs. This is what creates the basic discretion in a court to make a cost award. It says the court may determine by whom and to what extent the cost shall be paid. So it's not always the unsuccessful party, nor is it always any party, right? This phrase, these words mean that the lawyers themselves can be required to pay cost awards. Okay, and there's a special rule on this, and so we'll see here. This is where the court is getting into kind of a discipline of the legal practice, right? Regulating the practice of law in the context of civil litigation. Courts are not the primary institution responsible for regulating the conduct of lawyers in litigation. What's the primary institution? Where do we look first to regulate lawyer behavior and to get lawyers in line if they're out of line? Law Society, bingo. So the court has a secondary role here, and which they pursue using the cost system, and specifically using Rule 57.07, liability of lawyer for costs. Where a lawyer for party has caused costs to be incurred without reasonable cause or to be wasted by undue delay, negligence, or other default, the court may. So 57. So this subsection here, we're not going to talk about because that's between the lawyer and their own client. But this is the important one for our purposes, right? Subsection C, the lawyer personally has to pay the costs to the other party. Remember, normally with costs, it's the parties that have to pay. This is the exceptional circumstance. Okay, and the order can be made by the court on its own initiative, right? So you remember, you want to remember the case where we were talking about this, about courts doing things on their own initiative. What's the other big thing that a court can do on its own initiative? Because this means the standard rule is party control, right? Nothing happens in civil litigation unless a party asks for it to happen or initiates it. It's an exceptional case where a court does something on its own initiative without any party asking it to do so. Anyone able to throw up for us what the other big function that a court can exercise on its own initiative? Contempt. Yes, Joy's got it. That's right. Contempt of court, right? So that was Henko versus Hadenassani showed us that. So a court can do this on its own initiative or on the motion of a party to the proceeding, but no such order should be made unless the lawyer is given a reasonable opportunity to make representations to the court. So there has to be kind of a due process where the lawyer can defend themselves against this. Okay, so it fits in with kind of regulating lawyers. It also, of course, is just an aspect of this, right? Accounting for problematic behavior in litigation, and recognizing that if there's problematic behavior in the litigation, it may be the fault of a lawyer as opposed to the fault of a party. Now, this case you read, it's the second part of the Lammie versus Belair case, which is really the Lou Farrow case, right? Because it's all about this guy Lou Farrow, the original lawyer for Elaine Lammie. And you may remember Farrow is kind of a firebrand. He considers himself a advocate for systemic change and repairing a system which he sees as rigged against personal injury claimants. And before we get into the substance of what he did and how this rule is used here, I wanted to talk about something that Chief Justice McLaughlin said, which is quoted here, which kind of expresses the court's reluctance or how rare it's going to be to use one of these orders against a lawyer, right? And it gets into some kind of legal ethics points and some points about safeguarding the lawyer-client relationship, right? So they talk about the fundamental, down here, a lawyer should not be placed in a situation where his or her fear of an adverse order of costs may conflict with the fundamental duties of his or her calling. What does this mean? How is it? What conflict can be created? And conflict of interest, as you'll know if you've taken legal profession, you probably know it already anyway, is like a wedge between lawyer and client. something that undermines that lawyer-client relationship. How is it that making these orders of cost against lawyers personally can drive that wedge between lawyer and client and undermine the fundamental duties of the lawyer to the client? If you were a client and your lawyer were confronted with personal costs order, it's kind of a tricky one. There's one part of it is about the lawyer's obligation to take instructions, right? Fundamentally, clients give instructions, lawyers carry them out. And sometimes the instructions that a client will give to you are aggressive, right? Or maybe push the bounds of what might be allowed. And if the lawyer faces a significant fear of being required to pay costs personally, then that can lead the lawyer to second guess those client instructions too much, right? To basically say, okay, you want me to take an aggressive position in court, but I'm afraid that if I do, I might be subject to a personal cost award, so I'm not going to take your instructions. And we're very reluctant to encourage lawyers to refuse client instructions, because sometimes in pursuit of justice, you do have to not bend the rules, but be aggressive, right? And from Lou Farrow's point of view, he's confronting a system full of Avivas, right? Full of defendants who are wealthy and powerful and stack the deck and abuse the rules to the detriment of personal injury claimants. If he gets instructions from a client to take an aggressive position in court, we don't want him second guessing that too much for fear of costs being assessed against him personally. Sarah puts it well. The conflict may encourage the lawyer to throw the client under the bus. If the lawyer is faced with this personal risk, they might be tempted to tell the court, well, it's all the client's fault because the client told me to do X, Y, and Z. What's so bad about that? I mean, why is it that lawyers should not be telling the court what their client said to them? Yes, solicitor client privilege and the rule of the expectation of confidentiality in the rules of professional conduct. Okay, so this is all why it's exceptional, right? That we don't want to. This personal lawyer liability can undermine the lawyer-client relationship, so it's a rare order. Okay, but that being said, Lou Farrow comes kind of close and may have stepped over the line justifying it, right? You remember we read this case when we were looking at oral discovery and examinations for discovery, and he basically went nuts and kind of shut down the examination for discovery and went way over the top in his advocacy. The court goes through several things that he did, right? They basically review his whole conduct of the case to see whether what he's done is bad enough to justify this exceptional order. So it's not really a statement of claim, right? Pleadings, they say, they're supposed to be expansive. You can throw a lot of stuff at the wall and see what sticks. So he's not really in trouble for his pleadings, even though they were exceptional for personal injury in the sense that he's taking on these insurance companies in a more aggressive way. The examination for discovery is problematic, right? So that's paragraph 122, and we already read about what he did in the examination for discovery, where he went over the top, as I said. Another thing he did is this failure to drop these unsubstantiated claims, right? So he named the insurance adjusters and like the employees in the insurance companies personally. So the bold start, naming them in the statement of claim, is not necessarily unreasonable. However, to maintain this pleading, and keep it going up to trial when the evidence is not there for it is unreasonable, and he failed to do that. There's also a sense, so he's got an agenda, right? Like, to him, this is not just about Lammie and Belair. This is about fighting a big systemic fight. And the court says that this became a conflicting interest to his client, right? So what does that mean, right? Because his agenda, it's not the most insane thing in the world. He wants to expose the insurance industry, expose these captive medical professionals, and lawyers can certainly have their own agendas, right? It's one of the great privileges of being able to practice law is that some lawyers have an agenda for social change, which they pursue over the course of a career from case to case. So that in of itself is not wrong. But what's the conflict of interest between that and the specific interests of his client, Elaine Lammie? Money. That's right. She wants as large a compensation as check as possible. And when do we want it? Now, right? As soon as possible. So this is the interest you can presume for any personal injury claim. Well, I shouldn't say presume, but most of them want compensation as quickly as possible. And how did Lou Farrow's agenda undermine the ability of his client to get what she wanted? Okay, extra cost and time and process. Yeah, so the more people you're suing, the more evidence you're leading, the longer it takes. There's something else as well. Okay, yeah, so what is it? So let's talk about the other side and the offer, right? The insurer's offer. How did this decrease the chance of getting a good offer from the defendant? So people have got most of it, but there's also this idea that so his criticism against them and his lawsuits against their employees, right? So now, this is a big corporation. They want to have good relations with their employees. Their employees are being personally sued. That means, money could be coming out of their personal pockets. So they have to, this antagonizes them and makes them less likely that they're going to settle, right? And kind of gets their back up. Okay, so this is all example of bad behavior by a lawyer personally. It's clearly not his client telling him to do things. It's clearly him, which is why 57.07 is on the table. In the end, the cost order is that the defendants are entitled to their costs on a full indemnity basis. So you remember, this is very rare. This is where the defendants are going to get every penny of their costs. But what about who's going to pay that? Is it going to be Lammie personally, or is it going to be Lou Farrow? So under Rule 57.07, they're not going to make that order against him personally right now. Basically, they're going to give him a chance to come back. De facto, what happened was never had to pay it. There was some kind of settlement which we don't know about. The defendants most likely dropped their pursuit of having him pay costs personally, but he would have been, it would have been very unprofessional of him to not actually pay these costs, right? So this order means Elaine Lammie, his client, has to pay all the costs of the insurance company, unless he's like a total another level of jerk that there's no reason to suspect he is. He would have paid those, right? Because it'd be totally unreasonable to expect her to actually pay that money to the insurance company. But anyway, that's all speculative. Okay, so just keep in mind that's on the table, right? This exists. It's an exceptional remedy, but where it's clearly the lawyer and not the client responsible for the problematic behavior. The court kind of can shift into this disciplinary sort of mode and examine the lawyer's conduct specifically. Okay, so the 2 minutes that remain, I won't say much about these. These are cool pieces. I recommend them. They're short, snappy. This one's from Slaw. This one's from the Globe and Mail. And they're great illustrations, because right now we're transitioning, right? So next week we'll be into part 2 of the course, looking at alternative routes to justice. And the Matt Maurer and Alison Spiegel pieces really show why we need these alternative routes to justice. So Maurer is talking about, I recommend him following him on Slaw if you're interested in civil litigation, but about how vulnerable the system is to strategic game playing and delay, and how in many cases the court system is still, the cost system is inadequate to deter problematic intentional delay, especially by deep-pocketed litigants. And then Spiegel is basically a civil justice perspective on the access to justice problem, and the reality that she has to tell her clients, she's a civil litigator, she has to tell them that if they've suffered a wrong worth less than $70,000, $75,000, they may not be able to get justice for less than the value of what's at stake, right? So this explains why, and it's very difficult for lawyers. A client comes into your office and they've got a real strong case, something illegally wrong has definitely happened to them, and you could prove it at trial. You may still have to tell them that if they are if the wrong they've suffered is worth less than X, then it can cost them more than X to try to get to trial to assert that. And in her practice, X is $75,000. In my wife's practice, she says it's more like $100,000 when it comes to an estate. But X is high, right? It's a large amount of money. And this is the proportionality problem in a nutshell, that we have not yet found a way to let parties, to cost effectively create justice for claims worth less than $75,000 or $100,000. So just take a look. It really kind of sets up part 2 of the course in an interesting way. Great. So that brings us to our time. Thanks very much for being with me, and don't forget to vote. Election day is on Monday, and we will watch the outcome with bated breath. Have a great weekend.